Welcome back to The Explainer. Today, we're diving straight into a world that usually operates completely out of sight, the high seas. We're going to demystify the absolute labyrinth that is maritime penalties and vessel detention. If you've ever wondered how the law actually works when you're literally hundreds of miles from a courtroom, well, you're in exactly the right place. We're going to visually break down the framework that keeps global shipping in check, turning all that heavy legal jargon into something super digestible. Let's get into it. Okay, so here's our roadmap for today. We're breaking this down into 4 neat chapters: penalties, appeals in courts, corporate liability at sea, handling missing witnesses, and finally, detaining foreign vessels. Let's kick things off with Section 1, penalties, appeals, and courts. Basically, who hands down the law and exactly how you go about fighting it. You know, the legal process always starts with the initial penalty, and the law actually creates a very strict rhythm for resolving these disputes. Picture a 60-day ticking clock. Step 1 kicks off with the principal officer. That's the authority imposing the penalty. But you're definitely not left without options here. Step 2, if you want to fight that order, you've got exactly 30 days from the moment it lands in your hands to appeal to the Director General. And then, Step 3, the Director General goes on the clock. They have to resolve your appeal within 30 days of receiving it. It's a really brisk 60-day maximum turnaround designed specifically to keep the whole maritime industry moving. But before any of those steps can fully wrap up, Section 282 guarantees a really fundamental right. Because even in the hyper-fast-paced world of maritime shipping, the scales of justice demand basic fairness, right? Absolutely no order can be passed unless the parties are given a reasonable opportunity to be heard. You always get to tell your side of the story. Now, you might be wondering, what happens if someone simply refuses to pay up? Well, the law gives serious teeth to its enforcement. If a penalty isn't deposited, it's actually recovered as an arrear of land revenue. Think of that like the government seizing assets as if you hadn't paid your property taxes. It is a super powerful legal mechanism. Plus, cases can be tried wherever the offender is actually found. And because these cases get incredibly complex, the law demands top-tier oversight. We're talking a minimum of a judicial magistrate of the first class. Oh, and if a special public prosecutor is brought in, they need at least 7 years of practice under their belt. That makes sure only seasoned pros are handling these massive maritime offenses. What's really interesting here is how the law singles out very specific types of ships. Take a special trade passenger vessel, which is basically a mechanically propelled vessel carrying more than 30 special trade passengers. For the master or owner of one of these specific ships, penalties can actually only be enforced if a direct report is made by a proper officer. It just adds this extra layer of official oversight for vessels carrying a large number of civilians, which obviously makes safety the top priority. All right, moving right along to Section 2, corporate liability at sea. Let's look at what happens when a whole company breaks the rules. So think about this for a second. Shipping companies are these massive, complex beasts with hundreds of employees. If a giant commercial vessel commits an offense, who actually takes the legal fall? Is it the CEO sitting in an office? The captain on the bridge? The shareholders? Well, the law brilliantly splits this responsibility into 2 totally distinct camps. For the person in charge, so the one directly running the show when the offense went down, they, along with the company itself, are automatically deemed guilty. Boom. The burden of proof is entirely on them to show they either had no idea about the offense or that they used all due diligence to stop it. But for the high-level directors, managers, or secretaries sitting comfortably in a boardroom, the burden completely flips. They are only guilty if prosecutors can actively prove that the offense happened with their consent, their connivance, or due to their direct neglect of duties. It's a huge difference. Which brings us to Section 3, handling missing witnesses, keeping evidence afloat. Okay, picture this. You're building an absolutely airtight legal case. But by the time the actual court date rolls around, your star witness is literally on a boat halfway across the world. What on earth happens to your legal proceeding when that crucial witness just vanishes into the blue before court? Section 288 actually solves this exact nightmare with a super strict 3-part checklist for using past depositions instead of a live witness. First up, it has to be authenticated. We're talking signed by the presiding judge or maybe an Indian ambassador if they're abroad. Second, the accused absolutely must have had the opportunity to cross-examine them back when the deposition was originally made. And third, if it's a criminal case, that deposition had to have been made in the physical presence of the accused. The real genius of this system is that the official signature serves as hard proof that the accused had their chance to cross-examine, so the whole trial doesn't just sink because a sailor shipped out. Now, for the final and honestly most action-packed part of the legal code, Section 4, detaining foreign vessels, trapping a fleeing ship. The foundational rule here is remarkably straightforward but super powerful. Basically, if a non-Indian vessel causes damage anywhere in the world to property belonging to the government, an Indian citizen, or an Indian company, and that vessel happens to sail into Indian jurisdiction, the High Court has the absolute power to drop a metaphorical anchor and lock that ship down. If an application alleges the damage was caused by the misconduct or just lack of skill of the master or crew, the High Court will absolutely issue a detention order. But I know what you're thinking. That brings up an incredibly obvious logistical problem. Courts move slowly, right. Ships move fast. What if the captain realizes they caused damage and makes a mad dash for international waters before a court application can even be filed? Well, the law perfectly anticipates this. Any proper officer has the authority to detain the vessel immediately, which buys crucial time for the formal application to happen. And, as long as they have reasonable grounds to do it, that officer is legally protected from being sued over the delay. So, who actually carries out a massive detention like this? It's not just a guy with a clipboard, I promise you. Section 290 gives statutory power to a seriously impressive list of agencies. Under instructions, it can be detained by the Indian Navy, the Coast Guard, a port officer, the local police, a pilot, the harbor master, or even a customs commissioner. That is a massive, multi-agency net just waiting to drop over any vessel that tries to escape accountability. Now, the crucial point to remember here is that a detained ship isn't held forever. International trade has to keep flowing. The detention order only stays in force until the ship owner, the master, or the consignee pays up for the damage. Or, and this is way more common, they provide sufficient security to the High Court to cover all those potential costs. Once they hand over that security, the ship is free to sail, and the person who provided the security just becomes the new defendant in the ongoing lawsuit. It's honestly a brilliant way to guarantee financial accountability without permanently paralyzing global commerce. As you'd expect, defying a detention order brings some pretty disastrous consequences. If a master proceeds to sea after being officially detained, they are instantly guilty of a completely separate offense. But get this, what if a ship flees and accidentally, or maybe purposefully, turns the detaining officer into a stowaway? Seriously, it sounds like an action movie plot, but it actually happens. In that wild scenario, the owner, master, and agent are all liable to pay every single expense incidental to taking that official out to sea and, of course, getting them safely back home. Plus, they're slapped with another major offense. The court basically tallies up the expenses and recovers them just like a massive fine. As we wrap up today's explainer, I want to leave you with a thought. We've just seen how incredibly strict these timelines are, how corporate liability is meticulously weighed, and the sheer physical force nations can deploy to trap giant cargo ships. Considering the immense, almost unimaginable authority required to govern global waters, how do we perfectly balance maritime commerce with this level of heavy enforcement power? How do we ensure international trade flows freely without ever letting powerful entities just sail away from the consequences of their actions? Thank you so much for engaging with our visual breakdown today. Keep learning, keep questioning, and I will catch you in the next explainer.